Hello, good morning. Thank you for being with us today. Just a few short notes before we get started. If you have sound issues, please log out and then log back in. And if that doesn't work, please call in with the number listed on the registration. You can send us any questions that you have throughout the webinar by utilizing the chat box. If you have any questions about that, you can also contact Ashley at the email listed. It's agibbard@easternmichiganbbb.org. And we look forward to hearing your questions. Jeff Kopp is a partner and litigation attorney with Foley Lardner LLP. He is a trial attorney with a proven track record of success in labor and employment and commercial litigation matters. Jeff regularly provides employers with proactive employment counseling techniques to minimize the risk of litigation. He regularly advises corporate clients in labor and employment issues in merger and acquisition transactions and with complex FMLA, OFCCP, OSHA, and EEO compliance, unemployment, workers' compensation leave, Service Contract Act, and Davis-Bacon Act compliance issues, and non-compete and trade secret matters. Thank you, Jeff, for being with us today.
Oh, thank you, Laura. Good morning, everyone. And now I add COVID to the list of things that I think I'm fairly knowledgeable about. So let me just tell you a little bit about Foley and Lardner. You know, we're a national practice. We have a Detroit office, and it's about 50 attorneys in our office. It's one of the smaller offices, mid-size offices of Foley's national practice, but we have clients all over the U.S. and internationally. But our labor and employment group is particularly strong. We have about 75 attorneys that are actually now practicing full-time employment law. So I just wanted to throw that out, shout out to the firm. Today we're going to be talking about a couple topics and we have a group that's a small enough size that I'm happy to take questions, and this is a little bit more intimate than some of the other webinars I've given, but the topics today are, we're going to talk about getting back to work in Michigan. You know, you're all familiar with Governor Whitmer's orders that she's sent out. And so I think as we get back into the flow of what it might look like for your business, I think there's going to be different considerations for each of you. But these are the topics that I want to talk about, you know, the ADA, the Family First Coronavirus Response Act, and how that impacts your business. And then we'll open it up for questions and answers, and hopefully you guys have some time to ask questions that might be on your mind. Okay, so let's talk about getting back to work first. And I think, you know, as I said, there is no one size fits all here. You have to start with a plan. I think that the initial even Governor Whitmer's order requires a preparedness and response plan for all businesses, whether they're essential businesses and we're continuing to run during the shutdown, or whether they're now the type of business that's going to be phased back in and getting back into actually having employees come back to work. So I think each employer has to have a plan to reopen, and that plan is going to look different depending on whether you're a manufacturer, whether you're in an office setting, or the different parameters of your business. But all plans have to start with identifying people who are your task force, your team of people. You know, one person probably isn't going to be able to take on all of the responsibility that's involved here. It's a pretty monumental task to consider things like your, not just your PPE, but the physical layout of your workforce and whether you can stagger shifts. I mean, there's just a lot of considerations, and we'll talk about the kinds of things that will go into your plan. But really, I think it has to be a breakdown. We're going to talk about creating a safe workplace, what it's going to look like in terms of the phased opening, or are you going to be able to change your shift times for people and things like that. Reconfiguring the actual physical work areas, it might be a possibility. We're going to talk about sanitizing and disinfecting, and then social distancing, of course, and then things like taking temperatures and PPE. Okay, so those are a very high level of what we're going to be covering. But let me start with the task force. And as I said, you know, this is just an example. Here you see a team lead and logistics coordinators and, you know, somebody who's responsible for disinfecting. But I think in order to hold people accountable for the different tasks, and maybe, you know, your leadership team is going to have to look at the people and identify who you think is the best people for these different responsibilities. But for each business, it's going to be a little bit different, but it is important to think about, who's going to be responsible for what. And again, it's just, I don't think it's a one person fits all type, or one person is responsible for the entire plan type thing. It's a plan that should be subject to change. One of the things about COVID-19 that's especially important to keep in mind is that the science is changing all the time, right? And even today, I read a newspaper article about the temperature testing and how temperature testing might not be all that effective, and either because people are taking ibuprofen or Tylenol to get around it, or that it might not even, fever itself might not be a real indicator of COVID-19, that other symptoms like stomach pain or a lot of people are asymptomatic, but other types of symptoms might be more indicative, like the loss of smell might be more indicative of COVID-19 than actually temperature testing. So I think because the science is changing so frequently on this with this disease, I think you have to stay on your toes and kind of just follow it as it moves, but it is a moving target, and I think you just have to be flexible and understand that. But let's talk about, are you ready to open? When do you feel like you'd be able to go back to at least a normal state of where you were? Again, for every business that's different. Think about things like your contingency plans and what it's going to take to get the business going in terms of staffing. A lot of the different businesses, like our law firm, for instance, we're looking at a phased opening beginning in June with right now we have a skeleton crew that mans the office, very just essential people that are checking the mail and doing some accounting stuff in the office. The rest of everybody else is working at home, including, attorneys and staff, pretty much work from home. Now in June, that's probably we're going to see a phased in return to the actual workplace, with certain people coming into work in order to be there. Now, one principal question, I think, even under some of the executive orders that you see, is whether or not you could continue to work from home. You hear Twitter is doing it and saying they want their entire workforce to just be remote forever because of the risk of COVID-19. And that is a consideration I think you definitely need to consider, because of the potential liability if you expose employees unnecessarily to come back into the workplace. You're hearing about things like workers' compensation laws changing to add presumptions that people are going to be presumed to have gotten the disease if they are working on the job. And even if causation is very difficult to prove in workers' comp cases, but they're creatures of state law. And in Michigan, if you can show that you were injured as a result of working on the job, then you might be entitled to workers' compensation benefits, economic loss, and or lost wages and things like that. And so if you have COVID-19, it's going to be presumed with a rebuttable presumption that you can that the disease was caused as a result of workplace exposure. So unless you can really show that they got it through some other source, the employer might be liable for those things. So it's one of the questions that comes up is, well, do you really need to even have people return in the first place? Because if there's an opportunity for them to continue working from home, then you minimize the exposure there. Okay, so let's talk about the CDC has put out a lot of guidance on phased opening. Not a lot of guidance. I know the White House initially put out a 3-phase opening, encouraging telework on phase 1, minimizing travel. A lot of our clients are asking questions now about travel and, is travel necessary, or how does it interplay with the executive orders like Governor Whitmer's order? And the answer is that travel should only be done in essential. If you're a business that's operating right now, only essential business travel should occur, and that includes air travel or car travel. If somebody is not necessarily needed to, and they could appear by video conference like we're doing, then that would be permissible and probably something that's required under the executive orders as they stand right now. But things like eliminating guest access to your facilities. That's all part of this phase, and maybe it'll change. As we get into phase 2, maybe we're going to start seeing some loosening of the restrictions with respect to travel for employees and employees coming back into the workplace. One of the key things you want to think about during this phased opening is thinking about, is there enough time for cleaning and disinfecting? How is social distancing going to get enforced? And I know one of my clients said, they were watching their workforce, and the first couple of days, everybody had on masks and they were really staying apart. And then the next couple of days, they looked at the workforce and their masks are hanging on their ear, and they're getting closer together, and people are just starting to get tired of it and ignore the social distancing. And I think as employers, you're obligated to enforce the rules and make sure that people are doing what they're supposed to be doing. And I think this just falls into those same type of rules that you have to enforce as an employer. So sanitizing, pretty much common sense. I'm not going to spend a lot of time talking about it, but the key thing is that we focus on the common areas, things like your kitchens, your bathrooms, things where you may have to even think about your air systems. And there was a report on the news the other day about how just simply opening up windows and doors and allowing fresh air could really change the potential risk for employees. And so that's something to think about, and maybe having a contractor or somebody who understands airflow could come in and look at your facilities. But so that's something to think about. But just thinking about those common areas, and sometimes some of the questions we had from clients are, look, our people don't all have individual offices or in cubicles. How do you allow people to social distance when they might be very close to the person next to them with a common divider or a divider in between them? And it's tough, right? Because you see people putting up these plastic barriers or plexiglass or different things to try to keep people apart. But in a cube setting, I think the best you could do is probably spread people out, try to keep people as distant as far away as possible, and implement physical barriers as best you can. All right, let's and again, that's what I'm talking about with social distancing on this slide. Having signs that reinforce it might be good, but I think really it's just kind of training the employees to make sure that they understand that they need to stay apart, they need to maintain their safe distances, because treat everybody as if they're infected, kind of thing. Temperature testing guidance, again, most of the executive orders even on the county level, in Oakland County, for instance, and requires a screening. It doesn't necessarily require temperature testing, although it's recommended if you have the ability to use touchless thermometers to basically ask people to report or ask people to report their temperatures prior to coming into work if they exceed a threshold of 100.4, which was the initial CDC guidelines. So some states have lower amounts, 100 even, or 90, even one as low as 99 point something. Then that's something where I would tell you, if to enforce that, if somebody is tests with the thermometer and they come in higher than the threshold amount, then they should be sent home and watched for the requisite period of time until that fever goes away. Most orders have things like 3 days without a temperature, or 7 days from the first time that they had any kind of symptoms of COVID, and temperature or coughing or something to that effect. Or if they know they've been around somebody who's been exposed, then typically something like a 14-day quarantine is appropriate under most of the executive orders. Some of the questions we've had with respect to temperature testing have been, do we pay people while they're waiting to be tested? If you have a workforce where people are waiting in line, things like that. There's some questionable arguments or arguments on both sides that the waiting time's not compensable, but the general guidance and consensus among the practitioners is that generally you should pay people for that time that they're waiting. Hopefully it's a few minutes. It doesn't take all that long to take a temperature of somebody, but I think you can get around it with just requiring people to report their temperature to you. before coming to work, and you can do that. Okay, PPE, masks primarily are, most of the executive orders that I've seen from various states have requirements that people when you're in public, you're wearing a mask, and in the workplace, there may be times where people are in a public type setting and should probably wear PPE if they're around other people. I think, if somebody's in a closed office, once they get in their office, they can take off their mask, but the coming to and from is probably a good recommendation. And all of this kind of goes back and from a big picture, why do we really care about all of this personal protective, temperature testing? Why do we care? Well, number one, we care because I think obviously, we don't want our employees to get sick, but another component of that is the liability issue. There's obviously liability. You probably saw a couple of lawsuits filed early against Walmart and other big chains where employees are being forced to come to work, and because they were deemed to be essential at the start of this COVID situation, and they came to work, and they're saying their employers didn't properly safeguard the work environment. And so, as you know, under OSHA, you have an obligation to provide a reasonably safe workplace. That's the general standard, and that includes making sure employees aren't subject to known risks. And so, if you have a known risk that people could be infected, you have to do everything that's reasonable in order to protect employees from exposure. And so, while you don't have to have employees wear N95 respirators or anything like that, wearing appropriate masks or gloves or smocks or things like that, and provided by the employer, is probably recommended there. Okay. So I'm going to move on to talk just briefly about the ADA. I know I'm on a short window today, but I'm going to kind of rush through this a little bit. Let me just give you an ADA refresher. The Americans with Disabilities Act was passed in 1990 under the first George Bush, and there were very limiting things that employers could ask of employees about their medical conditions. The law was intended to provide that people with a disability are provided accommodations, and there were limitations about medical inquiries and discrimination against those people. So the law really has, although there were some amendments over the years, the idea is that people are provided reasonable accommodations. If they have a disability, they're protected if they have a disability or they're regarded as having a disability. And you couldn't ask medical inquiries about or examinations about employees and their medical conditions unless it was job related or consistent with the business necessity. What we're seeing is, as a result of the COVID situation, pretty much the medical inquiry part of this has been thrown out the window. Just the other day, the EEOC came out with guidelines about preparedness in the workplace for a pandemic, and that was the COVID-19 guidance that they issued on April 23rd. Basically says you can ask whatever you want. Employers, and you see on the screen the quote, employers may take steps to determine if employees entering the workplace have COVID, or because an individual with the virus will pose a direct threat to the health of others. So you can ask questions about what symptoms they had, also smell, test, taste, if they had nausea, diarrhea. I mean, back before this, you would never be able to ask an employee if they had diarrhea. I mean, it's just something that you wouldn't want to ask out of the blue because of the potential for an ADA claim. But now, you could go ahead and feel comfortable asking and learning that information to protect the workplace. Temperature tests before, like I'm mentioning with asking questions, temperature testing before March 17th, we would have told you, be careful taking temperatures of employees, because that's considered a medical examination under the ADA. After April 23rd, it's fully permitted and recommended by the government for you to do that. So another thing that's coming up is questions about reasonable accommodations. As part of the ADA, employers have an obligation to provide reasonable accommodations to employees who are disabled. And now in this COVID world, teleworking is going to be, I I think a common request for employees, because they've been working home for a few months now. Unless there's a real need to have the business to have somebody face-to-face working, I think you're going to see that it's a request from employees. And I guess from an employer's perspective, you probably, unless you can show metrics like that, there's a reason why the business will perform better if the person is there physically, then I think you're going to be hard pressed to show that you can't accommodate that reasonable accommodation. But if you can show metrics are off, or that it's not possible to that people are 50% less productive when they're working from home in your business, and you can back that up, then maybe that way you'll be able to require somebody to come to the actual physical workplace. But otherwise, I do think that we're going to see a lot more teleworking accommodation requests, especially as schools are closed and camps are closed in the summertime. Okay. Sorry, I think I went the wrong way. All right, so let me get into the FFCRA briefly. I'm just going to hit it from a high level again, because I know I want to have some time for questions and answers. The FFCRA was kind of a stopgap that Congress passed after the state orders started to come out, and they were looking at ways to help small businesses. The FFCRA, the Families First Coronavirus Response Act, was intended to help small businesses. It provides that if you're less than 500 employees, if you're a private employer with fewer than 500 employees, then you're covered under the act. There are some exceptions for very small businesses, usually under 50, but that exception is not a blanket exception. It's only with respect to certain people under that. So if a person is trying to take leave under this act, then that person with certain if they can meet certain qualifications, they might be exempt from the leave requirements. But generally, it's not an entire business, business exclusion from the act. Okay, the FFCRA provides two different types of leave. The first type of leave is what we call emergency paid sick leave. There's 80 hours that an employee can get for emergency paid sick leave. And then after that 80 hours, the other portion of the act is the Expanded Family Medical Leave Act. And then it's paid FMLA only in the case when an employee is not able to work because their kid's school is closed, or because they have a need for childcare. And so those are the only two. That's the only reason for the expanded family medical leave provision. So let me talk, and that's what you see on the screen. There is the requirement, or the breakdown of these two different laws. The benefit of doing this, or participating in this and providing these benefits, is that you get a tax credit as an employer. It's a one-to-one tax credit against the employer's payroll tax. So if you pay employees for this, keep track of the amounts that you paid for this type of leave, because you're going to get that back as a tax credit. There are 6 reasons why somebody could get emergency paid sick leave. The first 3 are really when somebody is, when they themselves are experiencing COVID-19 symptoms, or they're being told by a doctor to self-quarantine. And you see the rate of pay on the screen is, for them, it's their regular rate of pay, and it's up to $511 a day cap, or $5,110 in the aggregate. If the reason is for that they're caring for someone else because of someone else having symptoms, like a child or a parent, or their school has been closed, then the employee gets paid 2/3 of their pay for up to $200 a day, or $2,000 in the aggregate. So in the case with school closure and school closure alone, where you have a situation where the person is going to be out, they're going to be out for the first 2 weeks, is going to be covered by the emergency paid sick leave, and then it would continue for 10 weeks, potentially, if they haven't already exhausted their FMLA for a different qualifying reason under the laws that existed before this COVID went into effect. Then they're going to be able to take another 10 weeks and continue at that 2/3 rate for the $200 a day. So, and what you see on the screen basically is my summary um, of what I just mentioned to you. The kinds of things, so I'm going to make the PowerPoint available to you guys after, so you'll be able to go back and look at this if you'd like, but you want to ask, is employee eligible for FFCRA leave? Generally, they have to have been employed for at least 30 days, at least for the expanded FMLA. A new employee would be eligible for emergency paid sick leave from day one. Is the leave actually covered by FFCRA? So we had a situation where somebody was taking military leave, let's say, to go because they were being called up to go care for during the the COVID-19 response, but they weren't actually covered under the FFCRA because that's not one of the reasons why somebody would be eligible for leave. Do they provide sufficient notice? So we do have forms that are where an employee has to provide information about why they need this leave, and those forms can only ask for very certain information. You can't require a doctor's note, but you can require the employee to provide the name of the doctor, for instance. If they're asking for childcare, they have to certify to you when they're asking the request that they are not the only, that no other suitable adult is available to provide that childcare. So we've had questions from clients about, what if the employee's spouse is home and they could also watch the kid, and if another adult is home, then that might be a reason why you'd want to at least deny the leave in the first instance, and then determine the amount and rate of pay. Okay, so that pretty much just kind of summarizes what I just talked about. The content of what you'd be asking for the employee to provide notice, and that's what you see on the screen there is what you can require. Okay, another summary slide of the leave entitlement. Again, 80 hours maximum on the paid sick leave, the emergency family medical leave, 2 weeks unpaid, then the 10 weeks paid following the exhaustion of that emergency paid sick leave, which runs concurrently with the first 2 weeks of the emergency family medical leave act. Okay, regular rate, the only thing I'll say about that is just when you're paying the employee their rate, you have to keep in mind that it's not just their base pay, it would be also overtime or bonuses getting included into the regular rate when you're looking at overtime. So keep that in mind. Okay, last thing I'll mention is intermittent leave. Some employees could take leave intermittently, and that's, for the child care, for instance, it's come up, what if the employee just wants to do it intermittently, and they can, usually with the employer's permission, so they can do that intermittently. The other thing I would say is with the FFCRA, one key point is, if an employee is teleworking and they can work from home, then generally they're not going to be entitled to the benefits under the FFCRA, either the emergency paid sick leave or the family medical leaves, if they are working, right? So if they're working, they're just working from home during this time, then nobody's going to be eligible for those benefits. But if they do, there may be situations where somebody's home, but because they have small kids or something, they can't really focus on work. That may be a situation where they have the right to take that leave intermittently. Okay, so with that, I'm going to mention that we have a best practices work for COVID-19 preparedness that our firm prepared. I was one of the authors of this document. I think it's a great resource. We've had a lot of good praise for it. You can either write to Kayla, whose email is on the screen there, or email me, and we'll try to get you a copy of this. It's in a PDF form. And we'll also, if you need the forms for the leave requests, I can also make those available. So with that, I'm going to turn it over to questions and answers. I know I kind of went through this very quickly, but there was a lot of information, and I just want to see if there are specific questions that you guys have that you're not sure about as you're opening up, and how you're going to navigate this going forward.
All right, so if you have a question, feel free to drop it in the chat and I will read them off. We'll hang out here for a little bit longer to see if any questions come through.
So if I don't have any questions, I can throw out a question that I had from a client. Had asked, they have an employee who has been using intermittent leave for childcare under the Families First Coronavirus Response Act, and that employee they have reason to believe is working for a different employer part-time, and so they want to know, what can we do about that? And so generally, it's no different than a family medical leave fraud type situation where you have an employee that's calling off for a particular serious health condition, like, for instance, migraine headaches. Just use that as an example. You have an employee call off for migraine headaches and they say they can't work, or that they're doing something, or that they can't work because of that condition, but then you find out that they're working for another employer, or they're doing some activity that would be contrary to what their restrictions are. I think that would be a clear fraud type situation. So, keep that in mind, that the same rules apply with respect to the Families First Act leave. So if you see somebody working and doing something that would be inconsistent with their stated reason for need for leave, then I think you can investigate that further.
Okay, we do have a question that came in. This says, what are your thoughts about employers performing either CV testing or antibody testing?
I think that there's some risks involved with that. For the most part, most of my clients are not doctors or health professionals. So, the first question comes up is, are we really qualified to be doing, swab testing or blood testing or anything like that? And generally the answer is no. I think that it might be different if you were in such a business where, let's say you're working with adults in a nursing home. I think then to require employees to be antibody tested or tested to see if they're positive for COVID would be a good idea, but I think I would contract that out and make sure that I had the right company doing the testing, and hopefully we could rely upon the results, because I understand that the tests are not all that reliable, that there are a lot of false positives and false negatives, but I would be reluctant to advise a client to try to do that testing on their own. But again, certain types of businesses, it might very well be a good recommendation to do that. But especially something like a nursing home, that just comes to my mind right away. But for a typical manufacturer or office setting, I don't know that we're at that point yet where we're doing full-blown testing, coronavirus testing, or antibody testing.
Great.
Okay. Any others?
Nothing coming through right now. If
All right.
anybody thinks of any.
If anybody has any follow-up questions, I was going to say, my email is Foley and Lardner. It's jkopp@foley.com. I'm happy to, try to work with you. I do this advising clients, and our goal is to try to keep you guys out of problems and, away from problems and away from litigation, if possible. It's just trying to minimize the risk with different businesses, their risk tolerance, and trying to make sure their employees are taken care of the best they can. So that you can continue to operate. Because at the end of the day, one thing I did want to mention is, some of the questions that I'm getting from clients are, with the unemployment being so generous with the CARES Act, employees get an additional $600 a week for unemployment benefits. And now as companies start back, some of the our clients are saying that employees don't want to come back, right? They're afraid. We're getting a lot of those kinds of questions about, well, what do you do if an employee's afraid? They just simply don't want to come back. Well, you have to look at that on a case-by-case basis. I mean, there are some employees that you definitely need back, and there are some employees that are in certain age categories where they are more at risk than others. And in that case, you want to look at that and see, does that person need an accommodation, or or do we have to tell the person, look, work's available for you. You're a younger person. You're not in a high risk situation if they don't have a prior medical condition, and you want them to come back and you need them to come back, and you can pretty much report to the unemployment agency that work's available for them. Now, there may be, if childcare is still an issue, you know, that could be something where the unemployment agency takes a different position and says the person is still eligible for benefits, but it does make it a little bit more challenging now because those CARES Act benefits are, in some cases, are with unemployment that was available before. An employee might be getting up to $927 or $967 a week, and they might be making more on unemployment than they would be if they came back to work. So there's an incentive for that person not to come back, for sure.
Great. Well, if there isn't any more questions at the moment, like Jeff said, you can direct questions directly towards him, or if you want to send me your questions and I will shoot them over to him. My email is agibbard@easternmichiganbbb.org. Jeff also has a great best practices PDF that we will be sending to you after this presentation. So if anything pops up in the interim, please let us know. And thank you, Jeff, and thank you everybody for attending.
No problem. Have a great day, everyone. Thanks.